So this evening's webinar, I'm interviewing Toyin. She's a legal representative. She's worked for solicitors firms. Evicting tenants, that's her speciality. She's been doing that for nearly 20 years. So I'm talking to her tonight about the changing dates from 23rd of August for an extended 1 month to be able to evict tenants, and what the process is and what we need to do to evict tenants. So if you've got a tenant issue, you need to listen to this webinar. Very good evening to everybody. Thank you for joining this evening on my fortnightly, I run 4 nights and the mortgage broker runs the other night, webinar where we chat to property professionals and experienced investors and successful investors and find out exactly what's going on in their lives to make sure we're not missing a trick, and we're maximising everything we possibly can. So thank you very much for joining us this evening, Toyin. So yeah, if I could ask you to share a little bit of your background with everybody.
I'm a chartered legal executive, specialising in property law, property litigation, landlord and tenant disputes, practicing representing investors, housing association, banks and landlords in relation to a variety of litigation related matters that come from tenant evictions, come from options, come from contracts. It's not conveyancing, slightly different litigation disputes.
Cool, and I think our paths first crossed quite a few years ago when you were doing quite a lot of repossessions, acting for the banks in the Milton Keynes court.
Correct. Yes, that's how we met, I think some 15, 16 years ago now, maybe, Glenn?
Yeah, something like that. And I was always at court representing the vendor with the houses that I was buying. And I think
Correct,
I was frustrating your company a little bit. It was there to try and repossess the properties. And in the end, and then you ended up asking me to come and work for the building societies for the solicitors firm. So it was kind of me going from gamekeeper or poacher to gamekeeper, as it were. Right now, one of the reasons I've asked you on this evening is because I've been getting lots of questions. I know you sent me the link yesterday, which I thank you very much, to say that landlords can start repossessing again. We thought 23rd of August, but it's been extended now to September by 4 weeks.
Yes. Yes.
So what does that mean for a landlord with a tenant in arrears?
I do remember most of us, obviously, over the corona period, the Coronavirus Act effectively was rushed into an act of parliament. And there were various amendments, changes that effectively took effect from the beginning of middle of March. One of the most proponent effects on the landlords, buy-to-let landlords, was the suspension of the right to evict a tenant. And it applied across the board on commercial as well as residential. And the effect of the suspension was anybody who had either submitted a claim or served notice to a tenant on a residential property or a commercial property, they were not allowed to proceed with taking it further through to court during the period of the coronavirus. We were told at the start that suspension would only be for about 3 months, and then it would be reviewed. And then obviously we were told that extension happened till the end of August. And then we're now told that it's been extended a third time to the end of September. The consequences are quite draconian, quite dramatic from buy-to-let landlords' point of view, because I do a lot of litigation, although I have to stress, Glenn, I want to tell people about my club at the end, if you allow me.
Yeah, of course.
The Property Pillars Club, I'll talk about that later.
Yeah.
But basically, for most of my clients, the biggest impact is on the non-payment of rent arrears scenario that a lot of my buy-to-let landlords have now become victim of. I had a number of cases going through court anyway for my clients. They were based on non-payment of rent prior to the Coronavirus Act. Now, these
seem to have lost you, if you can hear me.
I apologise. I'm so sorry. Let me repeat what I was saying. I said the situation is really quite a sorrowful one for the buy-to-let landlords, because they're faced with having to deal with non-payment of rent from tenants who, because of the Coronavirus Act, you cannot take to court. And as you know, without a court order, you cannot remove a tenant lawfully from your property. So the buy-to-let landlords are the unfortunate people who are having to pick up the bill of this rather expensive draconian piece of legislation which suspends any form of litigation action against the tenant.
So,
so now what they've done, what they've done is they're proposing to also extend the notice provision to 6 months, because prior to coronavirus you had the Form 6A notice provision that was 2 months of duration, and you had the Form 3, which was 2 weeks duration. But they suspended that provision and said that you now need to give 6 months minimum notice to the tenants. So apart from the fact that you can't issue proceedings, or proceedings are suspended, at least up until the end of September, you also have to start putting in longer notices to those tenants during this period.
So what happens if somebody's actually in quite a bit of arrears? Do you actually put in to the court after September and then have to give them 6 months notice?
Well, no, you can put in the notice now and give them 6 months notice now, and when that notice expires, then you have to issue proceedings at that stage.
So even if they're in arrears now?
Yes.
You can only issue now, and that it's going to take 6 months to evict anyone from now?
Correct. So you can put in notice now.
Yeah.
The notice has to be for a duration of 6 months.
Okay.
And after the notice has expired, then you can issue proceedings at the county court.
Right, and what happens
now,
in
so there are some people who have issued proceedings prior to March, when the Coronavirus Act came in, and their hearings were pending in court.
Yeah.
And in those people who are sort of in the middle, they have to serve what they call a reactivation notice to the courts and to the tenants to tell them that they intend to reactivate the case. Now, if they don't serve a reactivation notice to the tenant and to the court, their case is automatically suspended.
Okay. And how long have they got to file a reactivation?
Well, we were preparing to file reactivation notices this week because we thought the courts were going to reopen.
Yeah.
Now that they've suspended it another 4 weeks, we're going to start serving reactivation notices in 4 weeks' time.
Okay. So what happens to the people that you're reactivating their notice?
Once you reactivate the notice, the courts will relist the eviction case and serve all parties a notice of a hearing for the possession action. So, but they have to see a reactivation notice first.
Yeah. But if you
that applies to those who are suspended in court.
Right.
So we have lots of cases in that situation. So we had cases, because we got about 20 a month of these sorts of things all over the country. So we had cases in various county courts, which got stopped because of coronavirus from the middle of March.
Yeah.
So we had the intention of serving notices because most of the landlords said, yes, it hasn't improved. As a matter of fact, the situation has got worse. We want to carry on where we left off, so to speak. So we're in the process of serving notices on all these tenants, and also serving a copy on the court with the view that we will be in a position to get the court to give us a hearing date to move the case forward.
Okay.
But since the courts are not now opening on the date that they've planned, which I think was today, we've got to do those notices at the end of September when they would begin to reopen and deal with eviction cases.
Okay. But those who hadn't served notice on, you're going to have to serve 6 months notice now of the eviction process starting in 6 months.
Correct.
So that's pretty horrendous for landlords, isn't it?
It's a bloody nightmare for landlords. I mean, I've got even possession orders that the bailiffs haven't enforced. I've had them in place since March, where we're literally just weeks away from the bailiffs coming in to change locks and do everything else.
Yeah.
And that's been on hold since that time. And the tenant hasn't vacated. And now they've given us another 1 month. That we'll have to wait another 1 month for us to put another application for warrant of possession from the bailiffs.
Okay.
I mean, I don't know how they expect landlords to foot this bill.
No, and I mean, I know some of them are on kind of a payment holiday from building societies, but they're going to have to catch up at the end. Although some cases they are actually allowing the mortgage to be tagged on to the end and extending the mortgage. But what about the bailiff's actual work at the moment? If they've got other cases non-property related, do you know whether they've suspended that as well, or whether that goes back to normal?
No, the bailiffs at the moment haven't been enforcing possession orders. I haven't received any dates from them. All I had was a letter from the bailiff saying that all suspensions are in place, Coronavirus Act. I'm assuming that will continue to take effect, especially now they've extended it. I don't expect to receive a date in the near future. Well, not at least to the end of September at the very earliest for the bailiff's appointment, because they're not enforcing any of the orders at the moment.
Okay. And for people who reactivate it, how long do you think it's going to take to get their tenants from them re-evicted?
Well, the provision said that once you've submitted the reactivation notice, within 21 days, you'll be sent a letter from the court giving you the hearing date.
Uh-huh.
So, but my guess is there'll be hundreds of thousands of people who are going to reactivate their claims.
Yeah.
And there'll be a huge backlog of hearings scheduled over the course of 2021.
Which is probably why...
And I guess it could take up to 6 months. I would say 6 to 12 months for you to get before the judge.
Right, okay. So, now I kind of run a poll over my landlords who were on my last Thursdays, and they probably had about 100 properties between them. And fortunately, there was only about 4 tenants actually in arrears. And it seems that the coronavirus situation doesn't seem to, you'll know better because you're on the front line of this, to have caused any more than the normal amount of repossessions. How have you found instructions?
I think we're yet to see the real backlog. I think it's because they're just laying low, waiting for all the court systems to go, because a lot of landlords have heard wind that we can't do anything about it, and they're managing their situations financially themselves. But once the systems go, we are going to be inundated with court claims for repossession on rental property. Because these people, some of them have lost their jobs over the coronavirus period. The people that were furloughed have not been able to go back. And some of them do lose their jobs, but just taking advantage of the situation. I think landlords are keeping low. They're aware of the situation, but they're waiting for all the systems to allow them to take action. And there would be a huge number of people bringing an action for repossession.
So if they are actually made redundant, then they can claim housing benefit, can't they?
Absolutely. Which is some of the things that we've looked at. They're able to claim housing benefit.
Up to a maximum amount, depending on the town,
Yeah, absolutely. They are,
So one of the things we've found out is that there seems to be quite a lot of builders that furloughed their staff. And they're paying their staff through the furlough scheme. And a lot of the builders seem to be working, but cash in hand only. So they're getting double wages at the moment. And I don't know how many people across the board are. It seems that there seems to be people that are affected bad, and the people that are ducking around the system are doing very well.
Absolutely,
So would you say right now that there's more than the normal amount of evictions? So if the eviction process was running as per normal, and but we were in the middle of the furlough and coronavirus act, with people not working or being furloughed and that, Do you think that there are more people in arrears now than there were prior to it?
I think yes. I think the answer is yes, because a lot of people have actually been laid off over this period, and they're not going. Their businesses have shut down. A lot of people have been made redundant. I don't forget the type of landlords I deal with. A lot of their workers. Some of them work in the hospitality industry, in the leisure industry, in restaurants, in clubs. So they take rooms in places, and those are the people who have been most affected, whose jobs.
So yeah, while we're waiting for Toyin to come back, it seems that there's quite a mess to be cleared up, and a certain amount of landlords that maybe, if they've got more than their fair share of paying tenants, are going to be in a bit of a cash flow challenge.
Well, come September, everybody's going to be really busy. What I'm actually doing is working, getting all the paperwork in order. As you can imagine, there's quite a lot of paperwork in any event we need to have in place. So I'm advising landlords to get in there early. The papers, I am submitting some to court. I accept that nothing's going to happen with it, but I'm quoting them by recorded delivery. It's just joining the queue, and I'm hoping that will be in the pile of stuff to be issued Thursday when they reopen the service. The court isn't sending the paperwork back. They're receiving them and not dealing with them. That's really what's happening. So I am still submitting some by recorded delivery, signed for. I know that they won't deal with it, but it's still in the pile of subject to proceed. So don't leave it till end of September, because everybody's going to try to do the same thing. If you've got a pending situation with the tenant, my advice is to speak to someone like myself to look at the situation. If we can't negotiate a payment plan, that is what the court is suggesting we try first, then we'll be serving them with the notice and getting the ball rolling. There's nothing wrong with serving notice now if we need to.
Okay. A few of my landlords that with their long-term tenants have actually come to agreement for 70% or 60% of the rent, but they're normally they tend to be the landlords that the mortgages are very low, and it's not essential that they collect because they're fairly wealthy, so they're doing okay. So some people have done that because they work on the basis that I'd rather collect 60%, because if they can afford that, they'll pay it. Whereas if they can't afford 60%, they'll probably not pay anything anyway. So sorry, Toyin. Yeah, you were saying that you're still putting them in, so they're there in the system, ready to roll when in September it starts.
Yeah.
And what's that? The 6 months notices that you're giving them?
No. The ones that have notices that have expired, they've done more than 6 months. Those are the ones we've sent the papers to court on. We've received letters back that there'd be no action taken on them, the standard letter that the court's sending everybody. But we've just kept them in the pile. We've just kept them. I know that the courts will deal with them when they're allowed to, but it's in there. We've got that confirmation that it's been received by the courts.
Okay, cool. So Lau's asked a question. Would a litigation case presented to court be addressed only at the end of September and then put into sequential queue or prioritised by case urgency?
Sorry, repeat that question. Ben, I didn't catch it.
So, if you present it ready for September now, so you actually have to serve the tenant 6 months' notice before you can actually submit notice,
Correct.
don't you?
Yes.
Okay. How are they going to prioritise them?
So in the case of, let's put the notice
Down to
in.
3%.
If the tenant, if the reason to put the notice in, get the notice in there, get the ball of the notice rolling, and we wait for the notice to expire, and then we submit the papers. But some of the ones I'm submitting now, we've done the notices much earlier on, 6 months ago.
Okay, cool. Graham says, do you know of any rent guarantee policies that don't include COVID-19?
I personally do not. I don't know of any, no.
Okay. So right now, I've got lots of comments about my sound in what you could hear. But right now I have no more questions for Toyin. You reckon there's going to be huge backlog, and what we're looking at, worst case scenario, if someone's in arrears now and you've not submitted anything prior to that you can resubmit?
It's just the financial risks that the landlords have to be prepared for, and the exposure to non-payment of rent and the financial damage it will do to the landlord.
So,
yeah,
go on, because you're a landlord yourself. So, have you got any of your tenants in arrears at the moment?
Yeah, I do. I had one tenant who lost his job. He's a chef, and he explained his situation. So for 3 months, we agreed a reduced rent.
Yeah.
He's in a position to start paying back the rent, and I've left it at that. So we haven't recovered the difference. I'm hoping one day he will give it back, but I know that he's now back in work and he's back up again. So that's the sort of thing that I did there.
Okay. So I've just had another question from Avi, or a statement basically, that says, my agent was trying to sell me a rent guarantee that includes COVID-19. And I suppose that's for new tenants, Avi, is it, that are coming in? Because by now people will know whether they've been affected by it or not. They know whether they've been... and, some properties people are vacating, moving on. So there are new tenancy agreements being created, every day.
Yeah. And in a situation like COVID-19, which is unprecedented and very, very unforeseeable, I don't know of any policy that would have been written with this sort of cover in mind.
No, I suppose...
certainly everybody would be interested in that.
Yeah, I suppose if you had a rent guarantee scheme, it would have guaranteed it regardless, but now they'll be missing it out.
Well, there's a force majeure clause, because they themselves, I have lots of service accommodation people calling me, because they provide some sort of rent guarantee, especially if they do rent to rent to their landlords. They never foresaw this would happen. I had one landlord, 27 or so units, practically empty at the peak of the COVID. He had to start phoning around and offering keys back to landlord, and he had offered everybody a rent guarantee arrangement. He just couldn't entertain the payment, and he was contractually bound, to fulfill it.
Yeah.
He was very lucky that some of those landlords didn't decide to sue him, but he would be in definite breach.
Yeah.
But it's such a situation that was unforeseeable, unprecedented. I think the courts would be very, very lenient towards him and his situation. But they want you to try to negotiate these things anyway.
Yeah. So are you dealing specifically with tenancy issues and, property issues, or do you deal with any other things that are being affected by the current situation?
I deal with, after 20 years of doing this, you know me, Glenn, you know me for ages. This legal thing is my bread and butter. I have to say that I wanted to do something a bit different, which brings me to what I'm talking about with my club these days. So I spend more time nowadays doing a lot less the legal, apart from the fact the suspension of the court, meant that I effectively don't have a lot of work in that area. But my desire now is to concentrate more on building my property pillars club, my network. I'm actually really enjoying that. And that is something that I'm really passionate about. I like working with people. You've been there before, Glenn. You spoke at our event and they loved you. And I know that some of them are really taking you on board as their mentor. So that's really what I want to be doing maybe sometime in future, which is to grow the network, the Property Pillars Club, bringing people together where people like yourself will come and train them, and they'll invest and learn more about property and network with each other.
Yeah.
So that's my plan.
What I found when I spoke that evening, I think around 30% of the audience were actually solicitors. It was quite
you know what they say, solicitors attract solicitors.
So, but if anybody wants information about Toyin's Property Pillars Club that she runs as a network event in London, and also I think you have like a WhatsApp group, don't you, more so than your Facebook group. If you drop me an email to info@glenarmstrong.com, we'll forward it to Toyin, and I'm sure she'll put you on the list to notify And are you starting to run events again? Because events are allowed up to 30 people.
Yes, events are allowed up to 30 people. We haven't started running events yet. We normally get a lot more than that, but we're thinking of starting sometime in October and November. But at the moment, we've been running all our events on Zoom, which has actually reached a lot more people than 30 or 40. We're reaching higher numbers. So we're also using it as our opportunity to rethink how we work as a club, because that seems to have taken off quite nicely with a lot of the members. They like that idea.
Cool. Well, I'm quite surprised at how few questions we're getting. If there is anybody in here that's got 5 or 10 or 15 properties, if you could give me some feedback, that would be great. To say how many properties you've got and how many are in arrears. What I've been trying to work out, Toyin, and I don't know if you've noticed, is there a north-south divide in the number of people in arrears? Are there more people up north in arrears than down south, or have you noticed anything?
I haven't really taken note, because most of the work that I get is in London and home counties. So I don't get very much in the north, so to speak. So I haven't really noticed, actually. I haven't noticed that, no. The only thing I have noticed is that certain courts form a lot quicker than others, and there are definitely inconsistency within the judiciary, depending on which judge and which court you have. There's certain courts, I can name them and shame them, that I believe are very biased to the landlords and make it very difficult for landlords to get possession orders. And the judges themselves are too lenient, too soft to the tenants. And then there's other courts that are very economical. They operate as a smooth operation, and they're quicker. And you tend to get the result that a landlord needs. And I know them. I know if I send proceedings to this county court and hits this judge's desk, I know it's going to be a hearing. But I know if I send papers to this court and hit this judge's desk, I know we'll be fine. And I see, because I do so much of them over, 20 years, a couple of thousands, I can tell you which courts are okay. And I know the sort of issues that the judges will deliberately bring. And so sometimes that makes me a little bit mad. It makes me a little bit angry.
Look,
but yeah, that's about it.
I know where, when I've been to court myself with tenants in arrears, and there are certain judges that when the tenant turns around and says, yes, but we're waiting for work to be done, which and I know isn't a justifiable reason for for withholding rent, where the judge has said, okay, that's fine, I'll give you time for the landlord to do the work so that you can then pay. And then me as a non-legal, officially legal person, turned around and said to the judge, well, that's not acceptable, that's not the law. You're not allowed to do that. And the judge has told me off and told me I'll be in contempt of court if I continue with my nonsense. So sometimes it's better to have a legal representative that can turn around and say, well, no, judge, you're wrong.
Yeah.
And I'm sure you've had that many a time where the judge have found...
Oh, definitely. Yeah. It depends who you're in front of. Some judges don't even really care very much about landlord. They see them as fat cats, people who make a lot of money from property, who can bear the brunt of it, and they see the tenants as individuals who are vulnerable, which some of them really are. But some of them are really down to their last pennies, and they're really struggling with many things in life that's affected them.
Yeah.
But you do get those repeatedly. I mean, I remember one lady that I evicted at least 3 times. I was instructed by 3 different agents over the course of about 3 or 4 years, and her name was just on my system every time. And I represented so many agents, especially Milton Keynes and landlords. This particular tenant, her name would just reappear. She'd come via, let's say, agency A 1 year. The following year, she'd come via another landlord B. The following year, she was just my persistent in my system, and I got round to see that she was a very beautiful actress. A lot of the landlords fell for her charm and her way, but she was a tenant that was deliberately bouncing from one landlord to the other, accruing rent and just living off the income from from non-payment of rent.
Yeah. So
Three times I had to move her from different landlords.
and is there
So you
anything?
do get people who take advantage very much of the system.
Yeah, and is there anything that a landlord can do about that? You know, really, they should have done some sort of due diligence on the person. Because whenever I
You see this thing of due diligence, Glenn, you and I, we talk about it a lot because you know what we do, we try to do is to get as much information about the tenant at the very start. Because I've always said something to any landlord, if you want every information, you take it from the tenant at the beginning.
Yeah, when they want the keys.
His bank statement.
Yeah, when they want the keys, they'll do anything to get it. And how I eliminated most of my problems was two things. First of all, when we asked for references, we asked for the references of the two last landlords, not the last one, because quite often the last one would give a good reference just to get rid of them.
Yeah.
So we did like two references, but we started in Milton Keynes. No matter who they were and how good they stood up, we would insist on a guarantor who was working and owned a property. And in Milton Keynes, with the supply and demand, we were able to get that. And so we went from at one point when I was buying loads of properties, I was over £100,000 in arrears with rent payments. And it was a nightmare. So we were doing lots of housing benefit tenants. I think at one point I was the 8th largest housing benefit private landlord in the whole country. So we learned the hard way, but in Milton Keynes, because of the supply demand, we could literally only insist on people that had guarantors. We had credit card details of the guarantor, and we insisted that they signed paperwork to say that we could take a month's rent if the tenant was 1 day in arrears. And they were so much better at collecting rent off of the tenants than what we were, because they'd ring up and go, look, can't we have 48 hours please, and we'll deal with it. And a lot of the time they chased them up and said, come on, what are you doing? We've got to pay this if you don't.
Yeah, of course.
So I've got a lady called Christine who says she's got 12 properties in Kent with 1 in arrears. And I've got a gentleman called Michael saying he's got 6 properties in South Wales, none in arrears.
Wonderful.
Michael says professional tenants in South Wales use the HSE environment to avoid making AST rent payments then disappear. I don't know if you've heard have you heard of that?
No.
Okay, I think they're the professional naughty tenants. And he also said DSS tenants decide to move on and a new landlord is preferred to the old landlord and landlords are left in arrears. So, I mean, there are quite a lot of challenges with being a landlord. And obviously the whole COVID situation hasn't helped at all. Things are where it is. And if anybody does need your help to evict tenants, what can you actually do to help them? Because they can send me an email at info@glenarmstrong.com and we'll forward them to you, Toyin. But are you able to deal with any more work at the moment other than what you've got at the moment?
No, I'm happy. Yeah, no problem. We can definitely. Got myself and my other team and my lawyers in my office, so I'm not alone. So most certainly we can. We can work remotely from any landlord in the Commonwealth UK. I'm happy to leave my mobile number as an initial contact or an email address, or they can come by you, Glenn, which is fine.
So I'm just answering someone's question on that. Okay, well that's brilliant. Thank you, Toyin, very much for giving up your time this evening to come and help me answer my clients' questions.
Thank you so much for having me. I'm sorry about the interruption, the technical problem earlier. I apologise to everybody.
No problem. It won't be the first time. there we go. So thanks very much for everyone for joining us this evening. We'll be getting an email out tomorrow evening to let you know exactly who's on. We've got a few shortlisted, so we'll let you know tomorrow. One more time, thank you to Toyin, and maybe you can come back in about another 4 weeks when the doors have opened and people are actually needing to start work on tenants, and you can give everyone a little bit more advice then.
I'd be delighted to do so.
Okay, thank you, Toyin. Good night, everybody. Take care and stay safe.
Bye, Glenn. Bye.